Welcome to Dealmaking with Laura DiFrancesco, the ultimate podcast for entrepreneurs and professionals eager to master the art of acquiring businesses. I'm Laura DiFrancesco, a seasoned M&A attorney and founder of Dean Street Law and a few other businesses. Join me as I demystify the complex world of mergers and acquisitions with in-depth insights and practical advice. Each episode is packed full of expertise, featuring discussions on the critical aspects of the acquisition process, from identifying potential opportunities to negotiating deals and successfully closing transactions. Whether you're a first-time buyer or a veteran investor, this podcast equips you with the tools and knowledge needed to navigate the mergers and acquisitions landscape with confidence. Welcome back to the Dealmaking with Laura DiFrancesco podcast. I hope you've been enjoying the podcast episodes that we've had so far. I'm excited for this conversation. We're going to be diving into navigating SBA guidelines in acquisitions. So if you are pursuing an SBA loan to finance your acquisition, this is a really important conversation to have, and I'm excited because we've had some big developments that we haven't seen in years in the SBA guidelines that have really promoted small business acquisitions and made a lot more possible. So I'm really excited to dive into this conversation. I hope that you will rate, give us a 5-star review, share this podcast with your friends, subscribe, of course, tag me on social media, screenshot it if you're listening on your phone. You can tag me at LMDiFrancesco on Twitter or at Laura DiFrancesco on LinkedIn or Search Funder, and Dean Street Law or Laura M. DiFrancesco on Instagram if you're all about the Instagram too. So I am so excited to dive into this. The SBA guidelines, it's really important to understand what the SBA guidelines are and how they influence deal structures, as well as what they change. First off, let's talk about a little bit into what the SBA is and what an SBA lender is, because it's sometimes a little bit unknown. So SBA is the Small Business Administration, and it has a role in supporting small businesses, particularly through its lending programs in the United States. And so the most relevant lending programs that it has are generally the 7A loan program and the 504 loan program. And so those loans are enabling the lenders to provide loans to small businesses and business acquirers with more confidence because it's backed by the SBA. And so in order for them to qualify, you have to meet certain guidelines. The SBA guidelines are the minimum standards that SBA lenders use in order to qualify a loan, but they may have substantially more stringent standards as well. And that's something that a lot of people don't realize. First off, it's not the SBA that's making the loan, it's a lender that's making the loan, and the loan is backed by the SBA. And so the SBA is not the direct lender, and as such, they have their requirements, but a lender that's an SBA lender may have additional requirements as well. So there is a minimum standard for any SBA loan, but you will see significant variance in the underwriting requirements for various lenders also. And then you have direct lenders and then lending brokers. Lending brokers assist you through the loan process, through your application process. They submit applications to dozens or several lenders on your behalf, and they manage that process for you. They assist you in getting the best loan for the best rate. They're not direct, but they're more sourcing, kind of like an insurance broker versus an insurance agent. I hope that's been helpful in kind of giving you a little bit of framework. We're going to dive into a little bit of the implications of the SBA guidelines and how that impacts your deal structure. So in terms of the implications of the SBA guidelines on deal structure, first off is eligibility requirements and how that is going to influence the terms of your loan. And so number one is going to be the size of the SBA loan. So there is going to be a maximum SBA loan. Generally, it's about $5 million, but if you use it in combination with multiple loan programs, you can exceed that as well. If you do, for instance, real estate plus the business loan. And then it also has operational criteria. So you're going to find general preferences, but those preferences for SBA lenders might be that the borrower has experience in the industry in which they're acquiring a business, but that's going to really differ from lender to lender. And the SBA guidelines are different than those preferences, and it will affect how you can receive financing. Let's talk about some of the guidelines that really influence the terms of your transaction and the terms and conditions. So they're most going to influence the terms of your seller note and what interest rates that you can have and what loan amounts that you can have with other loans, because those are going to obviously impact your debt to equity ratio or debt to enterprise value ratio. Those will influence your ability to successfully repay the loan, and of course will influence your SBA guidelines as well as your underwriting requirements from your lender, as well as the repayment terms, and then how those are going to compare to conventional loans. So generally an SBA loan has a more favorable interest rate than a conventional loan. That's generally why it's required. SBA loans do require personal guarantees. That is an SBA guideline, not a preference. And so anybody who owns 20% or more of equity in the business must provide a personal guarantee. So oftentimes you'll see we're going to dive deeper into seller retained or rolled equity. And generally that will be under that 20%. So it might be 19% so that the seller does not have to sign a personal guarantee for the SBA loan. So those are a few critical requirements. Also, if you are using equity, if you're using the seller note as equity in the transaction, if that's constituting part of the equity that you're bringing to the table, then that has to be on standby for 2 years. And that's a standard as well. So if you have a seller note, you should always be running those terms by your lender before you submit the LOI if you have that time in your negotiation timetable, so that you can make sure that whatever the lender will need to be able to underwrite the deal is in the LOI, so that you have the terms that are critical to the loan being approved set forth in your LOI, as that is the foundation of your entire transaction. That's going to be what the purchase agreement, the seller note, and other ancillary transaction documents are based off of. So in addition to that, you're going to generally have requirements as to the basic lending requirements. Aside from the SBA, is that the lender will always have to sign off on all of your transaction documents. So it's important to understand that and build that into your timeline as well. They may have comments as well. Common underwriting requirements, although not required by the SBA, is that you do have a non-competition, non-solicitation agreement with the seller. And generally, most banks like that to be the highest amount feasible under law. And while there are a lot of changing laws in non-competition, non-solicitation, it is different between an owner and an employee. And with respect to an owner, generally you can get 3 to 5 years, but it does depend on state law. Your lawyer will advise you on that. But I just said in a meeting that I spoke with BETA, New Majority Capital, just a few days ago, if you can get the seller to agree to the highest possible amount and highest possible territory, generally that's going to be up to 5 years, and the territories where the business is operating and where you plan to expand it to, and generally get as much as you can there, because your underwriting requirements, typically the lender is going to require it to be as much as possible that's available under law. And if you find during due diligence, once you've engaged your attorney, that with the state that it is, it's only available to be 3 years maximum, then it's easier to step it back to 3 years than it is to ask for an additional 2. So you always want to ask for more or as much as you can. And then when you are negotiating and finalizing and going through that due diligence process and you have a lot more information, you have the support of your attorney. If you don't have it an attorney during the LOI process, then you can make those refinements that you need to. Then the SBA does have guidelines with respect to the portion of equity that's required for the buyer. Generally, the deal terms that it will most influence will be the seller note, the non-competition, non-solicitation agreement, and any other financing that you may have. So let's talk about some practical guidance on SBA compliance and approval. Unlock the power of in-house legal expertise at a fraction of the cost with Legal Foundations. Gain immediate access to a comprehensive legal crash course for business, a rich library of on-demand video legal support, and the opportunity to apply for group consulting with Laura DiFrancesco as your legal mentor. Whether you're starting up or scaling your business, Legal Foundations has everything you need instantly available. Join now and position your business for success. Visit lauradifrancesco.co/the-shop for more information. Just like with any lender, it is a big application, especially a big application because it's the SBA. So gather all of your information. You're going to have to gather all of your information as well as the information of the seller. This typically will require 3 years financial from yourself, 3 years financials from the seller, as well as additional documentation, probably they're going to ask dozens of questions in underwriting, and you'll have to answer those. You will need to provide business plans and financial projections as well for that underwriting process. And it is a lengthy process. I also want to kind of walk you through the legal documents a part of that process because they're not always well explained and understood. So a term sheet is what a lender will say, here's the terms that we could offer if we go through a transaction together. That doesn't mean that those are the terms that they will underwrite or that the loan is approved. That's not the case. Those are simply almost sales sheets for what they can do. And they're subject to quite a considerable amount of due diligence and underwriting by the bank. And then you have a commitment letter. A commitment letter is also not an approval. It is the bank's commitment to loan if certain conditions are met. And those conditions are very heavily subject to underwriting approval. So the loan is generally not approved until right before closing, but it is a commitment letter, a significant step towards closing, and it should give the buyer significant confidence that the deal will be able to be closed, because with a commitment letter, the bank intends to close the deal as long as those conditions are met. It is a very lengthy process. I think sometimes people underestimate that process. I would expect for it to take a minimum of 60 days. It may take 45. That's great, but it probably is going to take a minimum of 60 days for that entire underwriting and approval process. That's why your exclusivity period that you have in your LOI should be tied to your turnaround time. So you should be talking to your lender, your vendors, if you're doing a quality of earnings or other financial analysis, asking that vendor what it's going to take in terms of turnaround for that. And then, of course, speaking with your attorney on timeline as well. I always recommend asking for at least 90 days or a 60 days plus 30-day extension that is automatic or that the parties can agree upon. That way you set yourself up for success. The way to think about it is in terms of transaction timeline. Let's say you have a 90-day period. Generally, the first 30 days should be spent on your due diligence. And after that, you should be drafting transaction documents, purchase agreement, and then ancillary transaction documents, because sometimes it takes the seller 3 weeks, a month to respond to the purchase agreement. So you need to build in that response time. And you don't want to go through your 60-day or 90-day exclusivity period all just on due diligence, because that's a really poor use of your time. You do need to use that time judiciously, because at that point, the buyer is investing significant funds and they're losing their bargaining power because the deal is getting sticky. It's becoming they're more invested, they have more sunk costs. And so they're losing bargaining power, and you have the likelihood of higher broken deal costs as it goes on. And so if you just say, I'm going to promise to close in 45 days, have an exclusivity of a period of 45 days, and then rely on the seller working in good faith and extending it at that point and asking for an extension at that point, that's really, really risky. You're really driving up your likelihood of broken deal costs if that's your approach. A way to mitigate that is having automatic extensions or having upfront conversations about what that transaction timeline looks like, and informing and educating the seller about that transaction timeline and why it's necessary. Also, at that point, if you have a business that's growing and you wait 45 or 60 days, the valuation may be substantially higher at that point, and they may not be motivated anymore to sell at this price, and you may find yourself in a situation where it's now competitive, or they're looking for more purchase price or something like that. So working with navigating that process, the most important thing is to understand how long it takes and work on it as soon as possible. If you have a non-competitive situation where you have a proprietary search and you found a seller and they're not in a bidding war and you're not in a bidding war, the best thing that you can do is try to get a term sheet, potentially even try to get a commitment letter prior to executing the LOI. Now, that's going to be dependent on the patience of the seller, how quickly they're moving, and what information they're giving you pre-LOI in terms of due diligence that the underwriting teams will need to be able to provide a term sheet or a commitment letter. It is a process, but the more that you can do in terms of getting the deal approved or closer to underwriting or closer to a commitment letter, definitely at least have a term sheet if you can. Pre-LOI, it's going to minimize the likelihood of broken deal costs, because whether it can be financed is ultimately going to be a huge impact, in addition to whether the purchase price and confirmatory financial due diligence is confirming and it is checking off the box that the business is financially in the same health that you think it is. Those two things are the biggest influences into broken deal costs and whether a deal is moving forward. So the sooner that you can get those done, the better. And of course, whether a deal can be financed is going to trump whether or not it financially is what you think it is. So that being upfront as much as you can pre-LOI, the better position that you'll be in. And if you're not able to get it pre-LOI, that you're really focusing on that post-LOI so that you get that confirmation and confidence that the deal will be moving forward. Be really organized in your documentation, be really organized in the seller's documentation, have constant communication with the lender. What do they need? Ask them what they need. Even if they're not telling you what they need a lot of things pre-closing. They need all of the transaction documents. They, of course, need everything for underwriting. Constantly follow up and have conversations to make sure that they're moving along in the process and that they're tracking with you in getting the deal done. So be very proactive. Thinking about buying a business? Unlock the secrets of successful acquisitions with Acquisition Insights, your legal roadmap for success. With over 81 modules of video lectures, written materials, guides, and checklists, we provide in-depth guidance to navigate every step of the process. From initial interest to closing the deal, get the expertise you need to make informed decisions. You can also access our battle-tested templates in the Acquisition Insights course and templates bundle, including letters of intent, pre-LOI and post-LOI due diligence request lists, material deal terms lists, and more. Visit lauradifrancesco.co/the-shop today and take the first step towards buying your dream business. If you have any questions on this, I would love to know. But just as a real quick summary, the SBA guidelines are constantly evolving. That's one of the biggest things to know. They're changing constantly. They are mostly going to influence your retention of equity and seller retained equity and who needs to sign a personal guarantee, as well as your other financing, including your seller note, and whether it needs to be on standby or what the repayment terms need to be. That's why it's always great to ask your lender what their thoughts are on the terms of a seller note. And I forgot to include one major thing, so we're going to loop into this and then we'll close things out. But because the SBA is now, I just talked about this in my last episode. So if you want to dive deeper into this and determination of asset purchase versus stock purchase, you can go back and listen to that. But one of the biggest things that the SBA has recently allowed is that sellers may retain equity. And so generally that's up to 20% because generally sellers won't sign personal guarantees. So generally that seller retained equity will be 19% or so if it is retained. Now, the SBA guidelines permit asset purchases or stock purchases. They do not say what it needs to be, but because most banks are very concerned with compliance risks, they're very conservative in their interpretation of SBA guidelines. So most banks at this point, June 5th, 2024, may change, of course, are currently interpreting the SBA guidelines to require that it be a stock purchase. And so if you're interested in utilizing that tool, seller retained equity, and utilizing that tool, it generally will need to be a stock purchase. Of course, speak with your lender. Lenders have the choice. They can decide whether an asset purchase is permissible. And of course, the SBA may promulgate additional guidelines to state explicitly that an asset purchase is fine. And so it would be seller retained equity in the event of a stock purchase and seller rollover equity in the event of an asset purchase, because in retained equity, they're just going to retain a portion. You're going to buy, let's say 81%, they're going to retain 19%, and you're going to amend and restate all of the operating documents and governance documents of the business. Whereas if it were to be an asset purchase, if the SBA lenders were to approve an asset purchase, it would be seller rollover equity. You would create a new co. They would own and roll over that percentage of equity into new co, and you would also own new co. So that's the general structure. Exciting new developments. We will publish additional episodes on SBA guidelines. If there are additional changes, I do expect that there will be more changes because of the prevalence of entrepreneurship through acquisition and how much it is being utilized in the SBA space. So I do think, especially as we have so many small businesses that need to transition hands over the next decade, that we will see additional regulations and directives within the SBA guidelines that are going to better promote and enable the transfer of those businesses. So I'm really excited for you to continue to listen to these episodes. Thank you so much for tuning in. I really appreciate all the time that you have invested in this. I hope that it's been helpful. I hope that you will rate, give this a 5-star review, tell us what you love, tell us what you want more of. Be sure to share on social media and tag me at DiFrancesco on Twitter, at Laura DiFrancesco on Search Funder and LinkedIn. Be sure to share with friends and anyone else that might be interested. I hope this has been helpful in your journey and given you a little bit more guidance into the SBA process and how the SBA guidelines influence your legal process. We have tons more information on the acquisition of businesses through Acquisition Insights. It is over 81 modules of videos, written materials, guides, checklists, and we have our template bundle as well with our LOI templates, pre-LOI due diligence request list, material deal terms list, and so much more. So you can check that out. And of course, if you'd like to work on it with us one-on-one, we would be happy to support you in your acquisition. And you can schedule a complimentary consultation with us at Dean Street Law. All the information's in the show notes. Thank you so much for joining me. I look forward to chatting with you in the next episode. We're going to dive deeper into crafting and negotiating exemplary letters of intent. I will catch you there. Thanks. Thank you for joining us on this episode of Dealmaking with Laura DiFrancesco. I hope you found today's discussion insightful and that it brought you one step closer to mastering the art of mergers and acquisitions. If you enjoyed this episode, please make sure to follow and subscribe to Dealmaking with Laura DiFrancesco on your favorite podcast platform so you never miss an episode. And if you found value in our discussion, please make sure to leave a 5-star review and share the podcast with anyone who may benefit from it. Sharing our podcast is the best way to show your support and help us to continue making more content just like this. So please be sure to take a screenshot and tag us on social media whenever you can. For more in-depth resources, be sure to visit our website at deanstreetlaw.com, where you can find articles, guides, and more information on our services. Or you can also visit lauradifrancesco.co/the-shop for more information on our legal courses. Don't forget to follow us and connect with us on social media for the latest updates, tips, and exclusive content. You can find us on LinkedIn, Search Funder, at LMDFrancesco on X, and at Dean Street Law on Instagram. Be sure to join us on our next episode where we'll be discussing more deal-making tips and insights. I'll see you there.